Hi, I'm Eddie Chase, and welcome to another episode of Prosecutor Brief. Today we're going to be discussing effective closing arguments in child sexual abuse cases. The best thing I can tell you is that you need to know the ABCs of closing. Always be closing. Your closing argument should actually begin the first time you step up in front of the jury when you're about to conduct your voir dire. The questions that you ask should have some sort of relationship to, number one, getting a fair and impartial jury, but also, are we going to be starting to lay the groundwork of what our theme and our theory is? You then carry that through your opening statements, through your direct examination, through your cross-examination, and then, of course, once you ultimately get to your closing argument. So don't think of closing just as something that you do at the very end of the case. It's something you do throughout the entire case. Think of closing also as this is not an opportunity for you to be a showman or a showwoman. This is an opportunity for you to really clarify some of the issues that may be still lingering in the case, and it's also an opportunity for you to bring all of the evidence and all of the testimony that has been heard throughout the trial together into one cohesive story. So the structure. You don't just want to summarize what each witness may have said. One of the worst things and most boring things a prosecutor can do is to get up and say, first you heard from witness A, and witness A told you X, Y, and Z. After that, you heard from witness B, and witness B told you X, Y, and Z. It's extremely boring to listen to, and you're going to lose the attention of your jurors. Instead of doing that, what you should be doing is weaving all of the evidence and all of the testimony together into that one whole story. So what did witness A and witness B say? How does that incorporate to the entire trial itself? Don't give us a summary of what each individual witness said. The jury's already heard that. Now's your opportunity to say what the entire story is. Here's another way to think about it. If someone were to ask you about a television show, and they were to ask you, what happened on episode 1? Perhaps that would be your first witness. You might summarize what episode 1 was. But if someone were to ask you what happened in an entire television series, you wouldn't start by saying what happened on episode 1, and then what happened on episode 2, and then what happened on episode 3. You would instead give an overarching story of what occurred throughout the entire series. That's the way you should be approaching and the way you should be viewing your closing argument. It's now your time to summarize how everything looks all together. So one of the things you also are going to have to do is you're going to have to address the defenses. But be careful here. You obviously have to address the major defenses that they put forward, whether or not it's consent, whether or not it was the child is lying. You're going to need to address those defenses. And you're going to need to address them with the evidence, the reliable evidence that the jury also heard throughout the course of the trial. What you don't want to necessarily do is to get caught going down the rabbit holes of every single thing that the defense wants to talk about. Let's say, for example, the police didn't collect a piece of evidence. Is that even relevant to the overarching story of what happened here? Just because they did not collect one piece of evidence, perhaps that piece of evidence was in a room that wasn't even related to what happened in the particular case. You need to be talking about why is the defense mentioning these things, and it's to distract the jury. It's to distract them from the real evidence that they already have. Law and the evidence cannot be mutually exclusive. You need to be discussing the law in conjunction with the evidence. So, for example, I practice in Georgia, and one of the jury charges that we're able to get is that the testimony of a single witness, if believed, is sufficient to establish a fact. Certainly, that's something that I can say to the jury, and I can tell them that piece of law. But if I just leave it there and I don't then expand upon that and explain how that really fits into the story of what they heard, it doesn't have the same effect as if I say, ladies and gentlemen, the judge is going to tell you that the testimony of a single witness, if believed, is sufficient to establish a fact. What does that mean? That means that if you believed the victim when she got on the stand, if you believed her when she looked at you in the eye, if you believed her when the tears fell down her face and she had to recount for you the details of what that defendant did to her, if you believe her, if you look at her eyes and you judge her credibility just like you judge the credibility of any other person in your life, and you believe what she has said, then the state has met its burden of proof. That's a much more powerful way to say things, by incorporating what actually happened at the trial versus just leaving a legal concept out there for the jury to interpret however they might. You also want to talk about legal concepts in a real-world way. Oftentimes people use for example, to talk about reasonable doubt, they'll use an example of a puzzle. And maybe not all the puzzle pieces are there in front of the jury. But if they take a step back and there's no other reasonable explanation as to what that is a photograph of on that puzzle, then the state has met its burden of proof. Find something that works for you to be able to explain complicated legal concepts in a way that the jury is going to be able to easily understand. Here's some other tips for you. Your perception is key. And what do I mean by that? You need to, from the very beginning, be building your credibility with the jury, from the time you step up in voir dire all the way through your closing argument. And if you've kept that credibility with the jury, then they're likely to agree with you and to be more persuaded by any arguments that you make at the end. So perception is something you need to be cognizant of the entire trial. Visual aids are key. Remember, not everyone is an audio learner. Some people need to learn by seeing things in front of their face. PowerPoints are extremely effective. Number one, jurors can see things and evidence right in front of them. But it also helps the prosecutor remember everything that they wanted to mention in front of the jury. Photographs, and even if the photograph is not of the abuse itself, a photograph, say, of the scene or of the home may help the jury visualize in their head what has happened when witnesses testify, and also when you are explaining certain aspects of your case. So instead of having to imagine, they can visually see it and they're paying more attention to what you're saying. And then timelines can be extremely important, especially if you have a child that has been consistent over time. Make sure you point out that timeline to the jury in something that they can see. Another tip: use real-world examples from high-profile cases, such as the Larry Nassar case. If you're trying to explain manipulation or grooming, that's a complicated issue. That's a complicated concept for a jury to understand. But if you draw from a well-known case, the jury may be able to follow you much more easily and agree with what you're saying. And then, of course, with these cases, it is always appropriate to have a certain sense of righteous indignation. No one in our community believes that abusing children is appropriate. Make sure that the jury cares. Make sure that your passion comes through in your closing argument, and it's going to make for a more effective closing. Thanks for joining us. See you next time.
Thank you for watching this episode of Prosecutor's Brief. If you have questions or comments, see the contact information listed below. If you'd like further information, please check the links to Calio, the NCAC online library, and other resources listed. As always, thank you for the work you conduct each day in protecting the children in your community.